All right, good morning, everyone. This is our civil calendar for Thursday, January 9th, 2025. I think we have a court reporter, Miss Flanders. I think you're a court reporter, so
That is correct, sir.
okay, fantastic. We have a pretty short calendar, so Judge will be on momentarily and call it, and I think we will get underway probably in the next minute or so. All right, just please remain muted until the judge calls on you. And then when she does call on you, don't forget to unmute.
Good morning. Okay. I only have a few positions on my calendar and hopefully we'll get you in and out of here fairly quickly. Position 1 is Capital One versus Joy Moore. Do I have anyone here on behalf of Capital One or Joy Moore? Okay. We will wait and see if they appear. And then I have Shine Investments versus the City of Atlanta and Kissburg Construction. Who do I have here on behalf of Shine?
Good morning, Your Honor. Brian Henderson on behalf of Shine, and co-counsel Tanya Tuttle has just entered her appearance as well.
Okay,
Yes,
thank
Your
you,
Honor, Tanya
Mr.
Tuttle here for Shine. I entered my appearance as co-counsel with Mr. Henderson yesterday.
Okay, excellent. Thank you, Ms. Tuttle and Mr. Henderson. And who do I have here on behalf of the City of Atlanta and or Kissburg Construction?
Good morning, Your Honor. This is Reggie Snyder here on behalf of the City of Atlanta.
Thank you, sir. And are you also operating on behalf of Kissburg or no?
I am not. I'm not sure if they have counsel.
Okay.
They're in default, Your Honor.
Okay, thank you for reminding me of that. I appreciate it. Okay, then I have Ponce Jones versus MARTA. If you're here on that matter, counsel for MARTA, Ms. Shockley, asked for a reset because she had to leave. So if you're here for that, you're excused. It was going to be reset. Okay. And then I have Arthur Charlow, if I'm pronouncing that correctly, versus S&L Messenger for a status conference. Who do I have? Understanding that there are some arguments about the limitations of authority of anyone here on behalf of Mr. Charlow, who is now deceased. Who do I have here on behalf of the plaintiff?
Your Honor, this is Stephen Kaplan. I'm here on behalf of the plaintiff.
Yes, sir, Mr. Kaplan. And who do I have? Who do I have here?
William Davis for the plaintiff as well, co-counsel.
Thank you, Mr. Davis. And who do I have on behalf of S&L Messenger?
Todd Marole on behalf of the defendant. Good morning, Your Honor.
Good morning, sir. And this one was on for a status conference. I'm going to get into the weeds with y'all on that in just a few minutes. Obviously, I understand that there is a couple of motions pending to stay the case, and I just want to talk to the parties about what's going on in the background that might I believe I previously entered a stay and then sort of nothing happened. And so the reason I wanted to have the parties come, it was just sort of educate me about what is attempting to be happening in the background that might change what is going on in my case and the stay that might be entered and how long it might last. So if you guys will be thinking about that, I'm going to dispatch these other cases here in just a moment, and I'll be back with you. Again, do I have anyone here on behalf of Capital One or Joy Moore? Okay. Mr. Freehoff, if you will please dismiss that matter.
Will do, Judge.
Thank you. Okay, so I am aware, first of all, I see a couple of court reporters here. Did Shine versus City of Atlanta, did y'all want this taken down?
I don't know that that'll be necessary, Your Honor. I think it's really going to be more.
I just wanted, if you wanted to, I just wanted to call it properly for the court reporter so she'd know where to start taking down. So but if we're not taking it down, really the main reason that y'all are here, this is listed as a non-jury trial. It is so I wanted to confirm that everybody was in agreement that this was going to be a non-jury trial to the extent that the motions for summary judgment are not dispositive. I am in the process of working through those summary judgment motions. I have made it through the city's motion. I've not yet reached the other motion that Shine filed. This is what I'm aware of generally in terms of the facts of the case. is that one property, that Shine had control of, two properties, that one was demolished pursuant to allegedly an out-of-date demolition order. And that one property is set to be demolished, and that there's an effort to enjoin that demolition from occurring. And Kissburg, I think, is only in it because they were the construction company that actually conducted the demolition of is it the Lamar property is the one that was demolished, and Wadley is the one that could be demolished?
That's correct, Your Honor.
Assuming for a moment that the motions for summary judgment are not dispositive of the outcome of the case, what do the parties think about what needs to happen next and how long it will take to try this case?
I think, Your Honor, that prior counsel had put this on the non-jury calendar. I think that we would actually request that it be moved to the jury trial calendar. I think that there are a couple of things that need to happen. Once the dispositive motions are ruled on, the court had previously ordered us to go to mediation on this case in December. We weren't able to make that happen with the change in counsel and with schedules. But quite frankly, I don't think it's ripe for mediation until there's a ruling on those dispositive motions. I think that'll put us in the position to actually mediate the case. And so my request would be that after a ruling on those motions, the court set some firm date by which we're to have conducted a mediation, whether that be 30 days after your ruling or something to that effect. But I think that's the route we would need to go to resolve this case.
Mr. Schneider?
Yeah, Your Honor,
Thoughts?
I agree with that. I think that the first step is to get a ruling on these motions for summary judgment. And if they're denied, then yeah, I think we need an opportunity to try to mediate the case, come to resolution if we can. I guess they have a right to a jury trial if they want it. But I don't really have a position on that. I think it's really proper for a bench trial, but it's their option.
Well, I understand that counsel has changed. So let me work through a couple of different things here. Number one, I'm looking at the docket to see how things were entered in terms of a mediation. Mr. Henderson, you spoke of an order to mediate. I don't typically order anybody to mediate. What I typically do is enter a scheduling order that has a deadline by which the parties should mediate if they're going to. If the parties want to mediate, they're free to do so at any time. I understand that you probably would prefer to have a ruling on your summary judgment motions, and that's fine. It had been my intention to try and, as I said, once I started working through them, to issue a ruling fairly quickly after that, in terms of notifying the parties. Excuse me. But if you want a jury trial, and you believe that is in your client's interests, I think you'll, as I read at least the initial complaint and the amended, I don't see clearly a request for a jury trial. I may just be overlooking it, but I don't see a prayer for a jury trial. And the nature, I understand that the theories of the causes of action in terms of inverse condemnation, et cetera, but initially the way this was filed was as an injunction and declaratory relief. And so, I don't necessarily have a problem giving you a jury trial if you want one, but there's nothing in the record that would indicate a request or demand for such. And so typically, there are a couple of things that are working against you in terms of having a jury trial here, and just being straightforward as I can. One is I don't see that one was requested in the initial pleadings nor in any separate pleading. And two, my standing order says if you had a jury trial and you get set for a pretrial, then you have to submit a consolidated pretrial order. And if you don't, you've waived your right to a jury trial, and we're all going to proceed on a bench trial. Also, because it was initially framed as a declaratory judgment and an injunctive type relief. Again, I'm not saying you can't have a jury trial, but if you want a jury trial, you're going to need to do something to perfect that request in the record, and then we'll deal with it from there. All of that is a long way of saying this. my intention had been to rule fairly soon on the motions for summary judgment. And so either the parties would then be proceeding to some sort of appeal if it is dispositive of the outcome, or it would not be a significant amount of delay to get to a trial. So the question then is, to what extent, if it is a jury trial, I know having a jury adds time for selecting a jury. And it also, we all know, adds time for the jury coming in and out of the room and some of the things we have to do in and out of the presence of the jury. But let's say, how long do you think the case will take to try, principally? And then we'll add a day to that for jury selection and for the extra time that juries add. What are your thoughts, Mr. Henderson?
I think 3 or 4 days, Your Honor.
Total, or with an additional one for jury presence?
Total. I think we can get it done in a week with the jury presence.
And Mr. Snyder, what are your thoughts, sir?
I agree with that, Your Honor. I think if it's a jury trial, probably a week at most.
Okay. Okay. What timing wise? So it sounds as if even if the court were to rule tomorrow on summary judgment motions, which I'll have lots of time to do because apparently I'll be stuck in my house with all the snow. Even if I were to rule tomorrow, it sounds as if the parties then want some time to take that and do with it as they might and go forward to a mediation. And so the question then becomes, assuming that we were all to do those things, would moving the potential trial of this matter, jury or otherwise, to February accomplish, assuming that I can give you a timely summary judgment ruling, would it accomplish what the parties need to accomplish in terms of your ability to get to a mediation and then prepare for trial understand it would be late February. So hang on, I can tell you exactly. It would be the week of February the 24th.
I think that would be tight for us, Your Honor.
Okay.
Just because we have 3 counsel involved at this point, plus an out-of-state plaintiff. I just think it might be hard to wrangle everybody in that short a time frame and then to prepare for trial. There's still, pardon me, still some depositions that need to be taken. Prior counsel, for whatever reason, didn't depose the witnesses that they noticed. So we have some things to do to get ready for trial.
I would echo that, Your Honor, just on behalf of Shine as well. Obviously, I think this is going to require a strong mediator, and to get in front of a good mediator, obviously, it can sometimes take a little time to, on top of our schedules, to find the schedule of a good mediator who might help try to resolve this before taking up the court and a jury's time.
Mr. Snyder?
Well, first of all, Your Honor, I think you can't have it both ways. If you're wanting to have a jury trial when you've never asked for one, then you can't then say we need all this extra time to do things to get ready for a jury trial. Bench trial, quick, simple. You do what you do and you go do it. And the notion of conducting additional discovery at this point, I don't understand that. I certainly would object to it. I don't think there's any discovery left in terms of time.
I'm sorry to interrupt, Your Honor, but your order makes very clear that we're allowed to conduct the depositions that were previously noticed, even past the end of discovery. And so those deposition dates the witnesses have been noticed by prior counsel. The order says that we can continue to conduct depositions. And so we're not asking for any special treatment there. That's just what the court's order allows.
I don't disagree with you, Mr. Henderson. I understood Mr. Snyder's concern to be that it feels like at the 11th hour, plaintiffs are expanding the scope. And I understand your position is we're just doing what we said we were going to do. It's just that the time has passed for all that stuff to be done. But again, what I'm concerned about is getting you guys to a trial or a resolution. And obviously I have to do my homework to get at least the first step of that there, which is to rule on your summary judgment motions, and intend to do so here today and tomorrow. I will let you know that it is typically my practice because it's easier to edit than it is to create from whole cloth. So what you can expect from me is an email from Mr. Freehoff that says the court is granting or denying the motions in full or in part. Typically we'll provide some explanation if there are different counts that are, what my theory is of why I think it should be granted or should not, and then ask the prevailing party to provide me with a proposed order that I can then edit. So that's what you can expect. And then once you have that, I'll get an order on file for you as quickly as possible, but you'll essentially already know what the outcome is, and then can undertake to get to get the case moved forward. I think what I would like to do, given Ms. Tuttle's very fair assertion that getting a good, strong mediator, particularly one with background in this type of law that has some understanding of these types of issues, I think it will be difficult to get one timely, but you can always cancel. And so I think what I'm going to ask the parties to do is to provide me with some notice that they have scheduled a mediation at the soonest available date, and that they, to be clear, within the next 5 days, right? I want the parties to notify Mr. Freehoff. The mediation doesn't have to be in the next 5 days, but I want to be notified that there is a date certain scheduled for mediation with a mediator among the parties at the soonest available date. And the reason I say that is this is not an invitation for you to schedule a mediation in April or May. I understand if the mediator you choose is one that is pushing to get dates later, that's fine. But if the parties are satisfied that they've obtained a mediator everyone can live with and that it's the soonest available date, then I will adjust a trial calendar to work with that. Because of course, if I grant summary judgment to any party in a manner that is fully dispositive of the outcome, you can always cancel your mediation while you guys appeal, because I'm sure everybody will appeal. Anything else that I need to address with you guys while I have you here, Mr. Henderson?
I don't believe so, Your Honor. I would just point out that in addition to the motions for summary judgment, we also have a motion to correct a misnomer that's been filed before the court. And so,
Yes.
But that's the only thing I wanted to bring up. Thank you, Your Honor.
Thank you, Mr. Henderson. Anything from the city, Mr. Snyder?
No, Your Honor, I think we've covered everything. Thank you.
Okay. So just again, to be clear, what I'm expecting from the parties is by, let's say Friday of next week, since tomorrow may or may not be an actual functioning day, that you guys will notify Mr. Freehoff. It doesn't have to be a notice on the record, but you do need to notify Mr. Freehoff by email that you've selected and scheduled a date with a mediator, and what that date is, so that I, to the extent that your case is going to move past the summary judgment stage, will know when to look at a trial date. And again, for now, that trial remains on a non-jury calendar. And really all that means is that means I'm not arranging to have a jury that day. But if the plaintiffs wish to revisit that issue and make such a request, then the court will consider it, given the legal rights that parties have to jury trials where one is asserted.
Thank you, Your Honor, and we'll perfect the record on that issue.
Okay, understood. Thank you all and have a good day.
Thank you, Your
Thank you.
Honor. Stay warm.
Yes, thanks. Okay. Next up is the Charlau versus SNL Messenger. Gentlemen, I see a court, actually, yes, I see a court reporter here. Did y'all wish to have this taken down?
That's my court reporter, Your Honor, for the defendant.
Okay, and so you did want to have it taken down, is that right, Mr. Marola?
Yes.
Okay. And for the court reporter's benefit, is anyone sharing and takedown? Nope. Okay. Madam Court Reporter, this is going to be a status conference in the matter of Arthur Charlau, SCHARLAU, versus SNL Messenger Incorporated, formerly known as Georgia Messenger Service, case number 24 CV 003424. I previously, before we went on record, got announcements from the parties, and I have here Mr. Kaplan and Mr. Davis on behalf of the plaintiff, and I also have Mr. Todd Marola on behalf of the defendant. So the reason I have you here today is that here's what I understand about the factual background of this case and the procedural background of this case. This case was filed back in March of 2024 on behalf of Arthur Charlau for an accounting of the company that he previously owned and I think had sold to maybe his son. I'm not exactly sure about that, but he definitely sold to someone and was seeking an accounting. And then sadly, Mr. Charlau died shortly thereafter, I believe in early April. And at that point, the court essentially denied a number of motions that were pending, particularly as to an argument of default, et cetera, against some of the defendants, because one, the plaintiff lawyers were not authorized to file those motions because Mr. Charlau was deceased and did not authorize the filing of the motions, and no one had substituted a principal or person authorized to make such decisions on their behalf. Also, there was a substantive argument about the way a document was signed, which I also disposed of. So then, because Mr. Charlau had passed, there was a request, I believe, for a stay so that, you know, an executor or administrator, depending on what state you're in. As I understand, there are dueling efforts in Georgia and Florida, I think. And then there's a case in Cobb County. There's lots of litigation related to this family and to this company. And what I am stuck with is I don't dispute everyone. I think we can all agree that the notice of substitution statute says what it says. And what I am concerned about, however, is that because of the way that statute is structured in terms of the timing requirement of substitution, that it sometimes leads to people benefiting from a delay in probate, where the case is in stasis because no one has been appointed, but the case can't be pulled out of stasis because no one has been appointed. And I understand there's some dueling probate issues, and I don't want to unnecessarily force the case to go forward, but at the end of the day, this is an accounting claim, right? Which I would assume would inure to the benefit of any estate that ultimately exists. And so basically, I wanted to take an opportunity to find out what is taking so long, what efforts have actually been made to move either the Florida or the Georgia probate matters forward. I think I received an informal report by email that one of them has moved a little bit further forward than the other. But I'm not quite sure I understand what is going on, what is taking so long, and what is the end game for this case. Because what I don't want to happen is an open-ended stay, because in my experience, open-ended stays, the case just stays forever and nobody ever comes back to it. And 3 years from now, we'll still be sitting here with a stayed case on the court's docket. And so if I'm going to stay the case, I at least want a reasonable amount of time, which I thought I'd already given, to ask the parties to be able to report to me what has taken place and when will something be able to be happening to move forward in the case. So I'm going to call on either Mr. Kaplan or Mr. Davis on behalf of the plaintiff, understanding Mr. Marola's position that neither of you are actually authorized to act on behalf of the plaintiff because Mr. Charlau is dead. And my understanding is there is no executor or administrator authorized to make decisions for the estate, i.e. there is no one to direct you what actions to take on behalf of the plaintiff. Because I guess technically there is no plaintiff right now because no valid legal entity has been substituted into the case. So with that proviso, Mr. Davis or Mr. Kaplan?
Your Honor, this is Stephen Kaplan. With regard to the Georgia proceedings, there was supposed to have been a mediation and then a hearing set for March 7th. The mediation, as I understand it, has been postponed because the attorney for Janine Eberhardt had some medical conditions, and so the court apparently extended the deadline for the mediation to, I think, sometime in February of this year, and then there's a hearing set on March 7th of this year in the Georgia probate proceeding.
And not being schooled in probate matters, Mr. Kaplan, what is the nature of the hearing that's set for 2020 for
I
March?
actually don't know. I keep requesting that, but apparently Meredith has had difficulty responding because she's got some medical conditions. I don't know. Mr. Marola may have a better understanding of what that is than I do. And then the Florida case is pending. The parties are, from what I understand, trying to prepare themselves for no hearing has been set, but they're trying to prepare themselves for a hearing for who should be determined the administrator of the estate.
Okay, and for my benefit and education, in the Florida case, who filed the suit, or who are the people that are disputing who should be named as the executor or administrator?
So Arthur had a daughter, Janine, who is our
Yes.
client, and then a son, Stephen, Todd's client.
Right,
And those are the parties in both of those proceedings in the Georgia.
right. And I guess to be clear, my question was, who filed the Florida one and who filed? I knew that they were dueling to attempt to be executors or administrators. I guess which one filed where?
So as I understand it, the Florida proceeding was commenced by Janine and the Georgia proceeding was commenced by Stephen.
Okay, thank you, Mr. Kaplan. Sorry for the interruption. Go ahead, please.
That's about all I can say at this time. Obviously, they have the Cobb County case as well. And in that case, the judge just signed an order consistent with the provisions and the decision in the Northside Corp case, said as soon as a administrator or executor is appointed, service needs to be propounded upon that person, and then that's when the time limit starts running.
Okay. What is the nature of the Cobb County action?
It's a lawsuit filed by Janine on behalf of her dad, seeking to recover on a promissory note that has not substantially not been paid by both Stephen Charlo and then his former wife.
Right. And is this the promissory note associated with the transfer of ownership of the messenger service?
Yes, it is, Your Honor.
Okay.
And that's why the accounting and the request for all the documents has been filed.
Understood. Okay. Mr. Marola,
Good morning.
good morning. What, now that I have a little bit better lay of the land, and again, I am aware of your position that the attorneys here are not authorized, although, you know, that's one of the problems I have with the way that statute works, is I find that there's some delay occasioned by it frequently. But in any event, what is your position? What are your thoughts on, I understand that you believe this case should be dismissed. But setting that aside.
Sure. So, a couple things. I think you have given them a reasonable amount of time. There is no end game. They can't provide any information. This is consistent with my discussions with my Florida counterpart. I'm also licensed in Florida. And
As am I.
What's that?
As am I. All the cool kids are.
Oh, there you go. So, very nice and convenient. Everything's by, email and video appearances and 5-minute hearings and 10-minute hearings and all that kind of stuff. So, they've done nothing since filing, these two. You want to talk about Cobb County? I'll talk about Cobb County too. But they've done nothing. And in terms of the 30,000-foot view of things, everything that can happen in your case and also Cobb County case can and should be resolved within whatever probate court takes jurisdiction over the estate. There is no harm to dismissing this case, getting it off your desk without prejudice. The underlying case here, the Cobb County, the note, there was a release. My client's position is there was a release from Arthur Charlo like 10 years ago on this. Okay? And his sister wants to say that he owes $1 million on this promissory note, that no payment's been made in like 10 years. Okay. Then they have this separate corporate records lawsuit in your case. The underlying litigation here, which I don't know, I don't expect you have reviewed. I think I sent you our objection in Florida. But Arthur Charlo started losing his faculties. And there was a guardianship action pending in Gwinnett County. And I'm not all familiar with the guardianship stuff, but service and that sort of thing can be quite quirky. Maybe you have some experience in your former career. But from what I've reviewed, you got to get service. There's these probate orders, get the personal service, all these one-page amendments to the petitions and all these weird things. When Ms. Eberhardt understood that there was a guardianship pending so that one of Mr. Charlo's friends could be the guardian and take care of his abilities, she picked him up and took him to Florida, to parts unknown. And my client couldn't find Arthur Charlo for a very long time, and they couldn't serve him. And we got this power of attorney. And then they filed these lawsuits. Okay. So we've raised all that. The Gwinnett guardianship, the taking of Arthur Charlo when he was not sui juris. And so there's an issue in both courts about whether or not Arthur Charlo had even the capacity to change his domicile to Florida. We've raised those issues in Florida. Okay. I think I sent you the kind of the 2-page docket, and I also sent you our object. Nothing has changed in the docket. I'm looking at it right now. I logged in, everything's online. It's real nice in that county. They've done nothing. Okay. If they are right, and Ms. Eberhardt becomes the administrator in a Florida estate, she can pursue all these things. And I should also say that, there's no, as she claims in Florida, that there's no assets in the estate other than the Cobb County lawsuit, which I find incredible, but I digress. So what are we fighting over here? I mean, she's saying that there are no assets other than this promissory note claim. Okay. They want to pursue this. They could have applied for temporary letters of administration or whatever the Florida counterpart is. They've done nothing. We've raised these issues. You send out these, do something by whatever it is, December 5th, 6th, whatever the date was. They did nothing. Florida did nothing. I spoke to Florida counsel. What do you want to do? I can't get information from my client. You asked for status here. Well, we can't get information. There's something scheduled in Gwinnett. There's something scheduled in the Gwinnett estate, and mediation was delayed, and there's some other court. We don't know. We don't know. So, I mean, what's the point? They took Arthur Charlo when he didn't have his faculties, moved him out of the state. Then they filed these multiple lawsuits with multiple law firms to try to bulldoze my client. Arthur Charlo passes, unfortunately, and then their authority disappears. And then you know what they did? Nothing. My understanding in the Gwinnett case, Hugh Wood is the petitioner's counsel in that case. My understanding is that he served discovery. He got some boilerplate, really non-responsive things. Like she won't even disclose where she lives. She put on her Florida petition that her personal residence was a P.O. box. They're looking for records on what she did with Arthur Charlo's assets in the 18 months after she took him from Georgia to Florida. And they're not responding. I don't know if Mr. Wood's going to file a motion to compel or go to trial or whatever the process is there. I don't know. But the point for your case is that you gave them time. They did nothing. They've emailed Chambers. They've never entered an appearance under Superior Court Rule 4.2. They still did nothing. When I emailed the court and said, look at this Florida docket, they've done nothing. They still did nothing. I don't know if that's 2 weeks, 3 weeks, 4 weeks, whatever it is. But here we are, and they've done nothing, and they just want this out there. For what purpose? I don't know. And I'll close with this. There is no harm in you dismissing this case without prejudice. My technical position is that the plaintiff has not appeared. No one represents Mr. Charlo. They could have gotten temporary letters or at least applied for it. They're afraid to because they don't want the issue of them taking Arthur non sui juris from Georgia to Florida. And if they are ever appointed in the Florida state, because they're not seeking to be an administrator in Georgia, they just filed a caveat, and then they got this discovery going, and there's some hearing date maybe. In Florida, they're saying, appoint me. They've done nothing since my objection, which was, let me see this. I want to say it was May. Where is it here? Yeah, I filed my objection on May 14th, 2024. And they've done nothing. And there's a couple of claims. I want to say it might be a medical bill or a credit card, a couple thousand here, a couple thousand there. So those are the other entries on that docket sheet. But they've done nothing. And this matter, the Cobb County matter, it's an alleged asset of the estate. And whatever court decides to take jurisdiction over Mr. Charlo's estate, that administrator can pursue these claims without prejudice. So with that, if you have any questions to me about what else is going on in these cases, I'm happy to answer. But I mean, I just think that these things hanging out there with no activity is just abusive. I mean, this is 9/15/14 stuff. It serves no purpose.
Thank you, Mr.
Since they're not
Marola.
prosecuting their estate matter.
Thank you, Mr. Marola. Mr. Kaplan, Mr. Davis, what of the argument that these cases are essentially duplicative or cumulative of rights that could be vindicated more appropriately in any probate of the estate of Arthur Charlo?
If I can, Your Honor, I'm no probate expert. It seems to me that Todd is correct that the probate court could adjudicate the promissory note claim. That would be an asset of the estate. I'm not sure the probate court would have jurisdiction to order the inspection of corporate records of a Georgia entity, particularly if it's a Florida court that probates the will or probates the estate.
Okay. So I think it should be clear that my real issue is that when I entered a stay in August and said, report to me by December, I expected something to happen between August and December, as in at least a temporary administrator with authority to direct actions on behalf of Arthur Charlo to be appointed. And then I understand that now there are dueling efforts to do so. But it does, and I understand that probate can take some time, but temporary administration, et cetera. I mean, typically there is an emergent or at least urgent need for someone to be able to handle the matters, the business matters of a decedent. And therefore, everyone is typically acting with some urgency. And that's not happening here, even in the face of disputes. And that's part of what I'm frustrated by. So I understand that Mr. Marola, I understand Mr. Marola's position, and I frankly sympathize with it. It just in the interest of full disclosure, that this lawsuit is just sitting here. And I understand your point, Mr. Davis, that if there is a need to inspect the books, it may not be something that can be compelled by a probate court. That's fair enough. But I am still concerned by the fact that no effort is being taken to actually satisfy the court's concern, which is, when is somebody going to have authority? Because I agree with you that that's how the statute reads and that's how it is to be enforced. But if you wait forever, I mean, on its face, you could wait. There is no statute of limitations on filing an estate, to my knowledge. And so you could wait forever and ever and ever and just make this case stay open forever. And that doesn't make any sense. And so all of that is a long way of saying this. If I stay the case, while I'm waiting, realistically, I've already given the parties roughly 5 months to get someone who has authority to direct actions to be undertaken on behalf of the decedent plaintiff. How much longer is it realistically going to take? Because at some point, the court might the parties urging the position of the plaintiff, not necessarily the lawyers, but the parties urging the position of the plaintiff in this case aren't acting in good faith to comply with the court's order to exercise expeditious efforts to get somebody who can make those decisions. What are your thoughts, Mr. Davis, Mr. Kaplan? A realistic amount of time?
Well, I'll be frank. I mean, I do think there is a potential for delay, given that it's so heavily litigated and there's pending actions, there's jurisdictional issues, all that. So to be honest, I don't know. I mean, we're not handling the probate matter. There's coordination issues. We're not probate attorneys. So you have a significant amount of discretion to enter a stay that you think is appropriate. And, I couldn't provide you any assurances that this will be resolved in 3 months or 4 months or any particular amount of time.
Your Honor, and
Okay.
one other thing I want to point out is,
Okay,
regard
Mr.
to-
Marola, I understand that you think the case should go away and that the court shouldn't stay the case because the parties are, at least on one side, not acting diligently. And again, I don't necessarily mean the lawyers, just to be clear, Mr. Davis and Mr. Kaplan. But Mr. Marola, understanding that you don't want the court to enter a stay, what in terms of how long would be reasonable or not reasonable?
I mean, I think Mr. Davis's response, said it all. I mean, he can't commit to anything. He acknowledges that, I think his statement was, you have broad discretion to enter a stay. In the same regard, you have broad discretion to dismiss the case. I think under 9/11/41, given the lack of activity, I think you have discretion for an involuntary dismissal without prejudice. And then maybe that, if they really think they have some legitimate claim here and they want to pursue some right on behalf of Arthur Charlo instead of on behalf of Janine Eberhardt, then maybe that's the inspiration that will get them to move off the dime. There's no statute of limitations issue here. Okay, it's not like, oh, if you dismiss it, then if we don't get an appointment in the next 3 years, we're going to lose our rights. I mean, there's just no prejudice. So, given him some amount of time, I don't know. I mean, he can't commit to anything. I would say give him 2 weeks to make at least an application. And if they don't even make an application, then just dismiss it under 9/11/41 without prejudice. Go about your business. And then if Mr. Charlo's estate wants to pursue something, they can with no harm. And this way, my client doesn't have to pay me to appear in your case for further updates when they have no update today. And so, in any event, thank you for your time.
Thank you,
Your
Mr.
Honor, may I interject something?
I was going to say that I did want to hear from you regarding that response. And so, yes, Mr. Kaplan, you may interject, and then we're going to put a pin in it and move on with our day.
One point I'd like to make is, in terms of a temporary administration, nothing has been done in the Gwinnett County case by Stephen to obtain temporary administration either. So I think the parties are in similar situations because they're combating each other in 2 different courts.
Can we respond to that?
I'm confused. I thought there was a pending probate matter in Georgia that was asserted by Stephen, and that the Gwinnett County matter was actually a custodial matter that pre-existed, that predated Mr. Charlo's death. Perhaps I misunderstood.
Yes, if I may, Your Honor.
Go ahead.
So what I was referencing before was, I don't know, 2-3 years ago, Mr. Charlo's friend hired some attorney. I think that attorney passed away and did a guardianship.
Right.
Okay. And that thing died on the vine because they never got service, because Mr. Charlo was taken to to Florida. They couldn't find where he lived and they couldn't get service. And so the case was just kind of out there. And then when he died, that case ended because you can't have guardianship over deceased. Okay. They filed, then after he died, whatever it says in this docket, let me see. They filed April of 24, their petition for administration in Florida. I want to say within a month or two later, my client, Steve Charlo, the son, he retained Mr. Wood and they filed petition for administration in Georgia. Okay, so the guardianship is in the Wayback Machine.
Right.
So you got Florida probate saying Florida has jurisdiction because Arthur died in Florida. Then you got a month or two after petition in Georgia saying Arthur didn't have the faculties to change his residence. Georgia, his last residence was in Georgia, and Georgia should administer the estate. So those are the two things that are pending now. Guardianship went away when he died. And so you have Florida State, where they've done nothing. You got Georgia State, discovery was, so she filed a caveat. Discovery's pending. They're trying to get documents and information. And then they were ordered to use some automatic order on mediation. That got bumped because of a personal issue. There may be some hearing down the pike, but I think mediation needs to occur first. That's there. But these attorneys are the ones that filed this lawsuit. Their client has done nothing in Florida. They want to maintain the case. They need to do something to get her involved. My client has no obligation and should not be anything, any kind of ping against him that he hasn't moved for letters, temporary letters.
Understood, Mr.
They're the
Morrow.
ones that want this case alive. We want to say, let the probate court sort it out, whoever wants to take jurisdiction.
Okay, so here's where I'm going to leave it. I went back and looked at my actual order of stay, and it required that the parties no later than December the 2nd provide the court with a status update about the probate matters. But it also asked for the parties to provide the court with a status update as to the continued need for this lawsuit. And I don't know that I've gotten a clear answer on that one, other than Mr. Davis's assertion that perhaps my court is the only one that would have the authority to order an accounting as an equitable remedy. But of course, Mr. Merola's position is there's no such an action could be refiled if the parties wanted to pursue it. I'm going to sit with that for a bit and decide what to do next. Because again, this feels to me like a lot of work and a lot of lawsuits for everybody seems to just be spinning their wheels, and whether that's by design or by happenstance is an open question. In any event, I'm going to enter an order probably today or tomorrow, at least advising the parties of what I'm going to do in terms of whether or not I'm going to stay. I think what I will likely do is stay the case fairly briefly and require that the parties file into the record, rather than giving the court informal notice, but file into the record some demonstration of an effort to obtain authorization, and that failure to do so may result in the dismissal of the action for lack of prosecution. Everybody clear on what I'm probably going to do?
Yes, Your Honor.
Yes, Your Honor.
Okay, excellent. Anything y'all need from me before we adjourn? Mr. Davis, Mr. Kaplan,
Thank you for your time.
Mr. Merola?
No, Your Honor. Thank you. Have a nice day.
Okay, thank
Be
you all.
safe.
Have a good day. Thank you. I'll stay warm and safe.
Yep, you as well. Thank you.